even in the Tornillo case, even in the context of talking about newspapers, that Tornillo, while it looks superficially like a press case, isn't really, according to Lewis. And then finally, the Pentagon Papers case, which was built. This is a good opportunity to review all this material, actually. Remember Neer versus Minnesota? Well, that looked like a press case. That was a newspaper that was suppressed, subjected to a prior restraint. That was the precedent for the Pentagon Papers case, where the court said, no, you can't enjoin the publication of information. But according to Lewis, the Pentagon Papers case wasn't a press case either. That the principle, the rule against prior restraint, applies as well to pamphleteer cases, which the court had decided, like one of the Jehovah's Witnesses cases, Lovell versus the city of Griffin, was a pamphlet case where the court treated the pamphleteer as though it was the press, and not a newspaper. And the court said in the Lovell case that any kind of distribution of material would be protected by the First Amendment, so that the Pentagon Papers case, that principle had been applied as well to civil rights demonstrations, where cities would have ordinances that say you can't parade without a permit, a prior restraint, and those laws were thrown out. So that the principle underlying the Pentagon Papers case was not protection for the press as an institution, as a separate preferred entity under the First Amendment. Rather, there was a broader principle that applied to all of us. So Lewis concludes that the cases don't support any distinction between newspapers and other publications or speech. And in fact, he points out that no case in history has said that the organized press has any preferred position. No case has relied on the press clause as the exclusive basis for its decision. And just to bring it up to date, remember in the Citizens United case, where the court's talking about whether corporations have First Amendment rights, and it's argued that that media corporations should be treated differently from industrial corporations, all other kinds of corporations. And the court says in Citizens United 2 years ago, we have consistently rejected the proposition that the institutional press has any constitutional privilege beyond that of other speakers. Doesn't sound like the court is buying into Stewart's thesis at all. And the court goes on in Citizens United to raise the same issue that we touched on in the Caldwell-Brandsburg situation, that is, who is the press? If the press is going to have this preferred position, how do we define who is the press? And the court in Citizens United said, with the advent of the internet and the decline of print and broadcast media, the line between the media and others who wish to comment on political or social issues becomes far more blurred. We'll come back to that in a minute. And then you've got Stewart's own opinions, which that's Lewis's book, the cover of his book, biography of the First Amendment. But Lewis is sort of gentle with Stewart on this point, because I think it can be fairly argued that Stewart's own opinions for the court are inconsistent with the thesis that he's pushing in this speech. That is, Pell and Saxby, there's an opportunity to say that the press has special status, special rights to interview prisoners that the rest of us don't have, and the court rejects that. Stewart rejects that. He wrote the opinion. And then there's the KQED case, where Stewart gets caught in the middle, and he does write a separate opinion saying that the press, because of its special role in our society, in gathering information, informing all of us, ought to be treated somehow differently than members of the general public. They ought to be able to use the tools of their trade. They ought to be able to go into a jail when something newsworthy happens. But he agreed with the general principles espoused by Chief Justice Berger in the majority, that there's no First Amendment right of access, and that the press has no greater right than the general public of access. So how can he agree with that on the one hand and say that the press has special First Amendment status on the other? I got an email yesterday, speaking of access to prisoners, the Pell and Saxby problem. I got an email yesterday from a freelance reporter in Portland, Oregon, who was doing a long-form story for a Portland magazine about a serial murderer who happens to be in prison up in Washington State. And while he was in the jail in Oregon, she established a good relationship with him and started writing the story. And she wants to go interview him up in Washington. And she wrote a very diplomatic letter to the warden of the prison in Washington saying, can I come see this guy? I'd like to bring a cameraman and take a picture of him too. And the warden writes back to her, not a brush off at all. We're a very progressive state. We have very open policies. Make a lot of accommodations for the press. But we have a rule that says that there will be no press interviews of people who are locked up in the maximum security section of the prison, where this guy is. So what should she do? I'm going to talk with her this afternoon, but I mean, the bad news is Pell and Saxby still the law, right? And even though there's no interference with prison security by this press activity, the press doesn't have any right to come in there and interview her if nobody else does, interview the prisoner if anybody else doesn't. So then, the third standard by which Lewis says that the Stewart thesis should be tested is one of principle. This is a sound principle that the press has greater rights than the public, is a good public policy. And Lewis's view is that if the press is treated as an institution that has special rights, that there would surely be calls for imposing accountability on the press, that in our tradition we don't like institutions that have power that are not accountable in any way. Maybe treat newspapers as public utilities. They certainly would be subject, if they're going to be autonomous and have preferred rights, then they ought to be accountable in some way, maybe treat them like a public utility. The press often says, well, we act as a fiduciary for the general public. We're, the general public, they're our constituents, and we act as a fiduciary for them, taking care of them, providing for their information needs, and so on. Well, usually if you're a fiduciary, you would have fiduciary duties that go with it. That people would say, well, if the press is an autonomous institution that has preferred status in some way, then it ought to have duties in some way to serve the public in ways that they would want to do. And then Lewis picks up the definitional problem again about who is the press that Stewart wants to favor with special status, recognizes the theory of our First Amendment that the lonely pamphleteer has the same First Amendment protections as the publisher of the New York Times, and wonders about all of the modern type of communicators, now bloggers, who have appeared, of course, since Lewis wrote all this. All of us can be publishers if we want to be on the internet, but if the concept of the press is broadened to include communicators of every ilk, then, as Lewis points out, Stewart's thesis loses its point. There's no the established press. If it includes everybody, then nobody has any preferred rights. And finally, Lewis says that singling out the organized press as a specially protected class is inconsistent with the kind of country we are, our common values, the idea that we try to be a class-free society, and with the idea, it seems to me this is not Lewis's idea, that if the modern view of the First Amendment as expressed in Citizens United is that it protects speech, regardless of the identity of the speaker, why then would you give special protection to a particular class of speakers that you label the press? So, in my view, Lewis has effectively demolished Stewart's argument. And yet, I'm not comfortable with that. I still want to think that the press does have some different status. Its explicit mention in the Constitution means something. The framers must have meant to give the press something more than a recognition, something maybe structural, although I'm not sure what structural means in this context. That's what what Stewart said, that it's a structural provision. But if you look back to the framers, James Madison, and look what they said about the role of the press back in the day, it's pretty clear that they were thinking the press is something special and something different, and that safeguarding the rights of the press really does make a difference. Remember when the Sedition Act was enacted in 1798, Madison went back to Virginia and got the Virginia legislature to pass resolutions that opposed the Sedition Act. And in his memorandum, or whatever he called it, to the Virginia legislature, he says, "To the press alone, checkered as it is with abuses," recognizing that the press is not always responsible, "the world is indebted for all the triumphs which have been gained by reason and humanity over error and oppression. That the press conducted the people to the ranks of a free and independent nation, and have improved their political system. And if the Sedition Act had been enforced against the press in revolutionary days and pre-revolutionary days, had it been enforced, might not the United States have been languishing at this day," that is 1798, "under the infirmities of a sickly confederation? Might they not possibly be miserable colonies groaning under the foreign yoke?" In other words, the press played an important revolutionary role in the creation of our nation. And they're not just saying thank you in the First Amendment, where they say we want to protect the freedom of the press. They're saying that the press is an important institution, has made a difference, and we expect it to continue to make a difference. Well, I believe that the framers must have had that in mind. But in the real world, what difference does it make who wins this argument, Stewart or Lewis? What practical consequences flow from the recognition of a structural protection for the press in the First Amendment, as opposed to none? No special rights. Well, we've encountered those two, and they're the only two that I can think of. That is the confidential source problem and the access to information problem. That if the press has special protections by virtue of being the press, then its reporters should not be subjected to subpoena to give up their confidential sources. That the Brandsburg-Caldwell case should have come out the other way. And then on the access to information thing, where you've got a situation where the press can't go find out everything, where the people, individuals can't go find out everything they'd like to know, the press acts as the agent for them and is entitled to special access to jail or to government information more generally, that would be a useful thing to have happen, and that would require recognition of the press as having special rights that the public doesn't have, and that's what the court rejected in the KQED case. So in the only two practical situations that I can think of where it would make a difference, the court has decided against press exceptionalism. You have some odd cases where there seems to be a tension, maybe a conflict, between speech interests and press interests. And you remember the Bartnicki case, the interception of the cell phone conversation case, where the press got a hold of the recording of the cell phone conversation and published it. And the Supreme Court decided that because the newspaper and radio station that published the tape had not themselves intercepted the conversation, and because the content of the tape was of significant public concern, that the First Amendment protected the publishers from liability. That sounds like a press case, and in fact, some people have pointed out that the speech interest in that case was the interest of the conversants, the people in the telephone conversation, the cell phone conversation, who needed to speak freely to each other, and they assumed that they had the privacy to do that, and we need that privacy in order to speak frankly about things that we are thinking about. And that speech interest was damaged by giving the publishers of the purloined conversation the right to publish it. So there's some tension there. And then there's the Tornillo case, the Miami Herald case, where the speech interest is that of the political candidate who wants to get his side of the story told in what is basically a one-newspaper town, and there's no other outlet for it, and that newspaper has attacked him. The speech interest is his, getting his story out there, while the court protected the newspaper rather than the would-be speaker. But in no case, as I said, in no case has the court decided that the press clause gives the press, however defined, any special rights. You can say that the speech clause is more directed toward the interest in individual autonomy, in being able to give expression to our thoughts, to say what's on our mind, and that the press clause is more of a recognition for the press as being essential to our democracy, a check on government power, and so on. But there really doesn't have to be. There's an awful lot of overlap. There really doesn't have to be any clear distinction between speech and press. And my guess is one that Lewis speculated about too, that the framers probably included the press clause simply as a recognition that it had been the press that had been subjected to seditious libel prosecutions, prior restraint, and other forms of censorship. Maybe its inclusion in the press clause, maybe the inclusion of the press clause was just cautionary. Look, everybody, the press is important. Don't fool with them. And maybe it was never intended to confer specific, special rights on reporters that the rest of us don't have. But we'll never know what the framers' intention really was. That's all I got to say about that. Any questions? Bob?
What about with like the newspapers or press members covering things like unlawful subjects or things that they're in a park in New York City and they're trying to see what's going on with cops coming in and protesters and aren't seeing what else would there be like
Yeah, sure. There's no basis for the flip side. That is that reporters have fewer rights than members of the general public, and certainly targeting reporters, singling out reporters for special, harsh treatment would be unconstitutional. But it wouldn't have to be based on the press clause.
We're just not necessarily singling out for harsher treatment, instead they're singling out for movements so they're not even doing their job to report on that.
Yeah. Well, but there was a case last year or the year before in Boston where somebody walking through the Boston Commons, parked in the middle of Boston, observed the police rounding up a couple of people and arresting them and handcuffing them and pushing them around, and it was rough stuff. So the person who was walking through the park used his cell phone to take video of the police activity and was arrested for interfering with the arrest. And there was litigation about it, and the First Circuit Court of Appeals said the fact that this wasn't the press, he was just an ordinary person who was recording government activity, doesn't mean that it's not protected by the First Amendment. You don't have to be the press in order to be protected. No, it works both ways. They cited, by the way, on that, the K2ED case, that this should be treated equally. Kimberly? How would you define the press? Well, all of the shield laws around the country attempt a definition of the press, a definition of who has immunity from being subpoenaed to disclose confidential sources, or in California, unpublished information. And the California Evidence Code, Section 1070, and Article 1, Section 2B of the California Constitution say that if you are employed as a reporter for a newspaper, radio or television station, and there's some catch-all at the end of it, then you have the right not to be subpoenaed to spill the beans and so on. So they've attempted a definition of who's protected by these laws. Purely mainstream people. The California courts have interpreted that provision broadly, and at least one court has said that bloggers are included. But you have to, in order to have that special status, that has to be your occupation. Whether you're employed by the San Francisco Chronicle or self-employed, that's got to be your occupation. Marty? Yeah, well, the government can always, and does, give press passes to reporters and give them special access. They can go behind police lines, they can go behind the fire lines, they can go to the governor's press conferences. They get a lot of perks for being reporters. But that's because government wants them to have those perks, not because government is required to. They don't have to do that. They can treat reporters just like everybody else. But it serves government's interest, serves the officials' interest, to allow the press access that